Thanks everyone for joining today. We're going to be talking about what I think will be the hot topics or kind of things that we'll see play out for the next 12 months. I always think it's good to take the time at the end of the financial year to kind of reset and look at what I think is going to be on the radar for the next 12 months. In terms of the webinar, so I'll go through the topics that I think, but I'm also happy for you to pose questions as we go through. Just put them in the chat box and I'll do my best to answer those as we go through. If I don't answer them as we go through, I'll leave some time at the end to come back and have a look at those. In terms of what we're going to talk about, so we're going to talk about the recent minimum wage decision and also the reasons behind that decision. I'm also going to talk about employees and contractors because we've had a very recent decision involving Deliveroo and we'll look at that decision, and it's also a topic that the Fair Work Ombudsman is very focused on. So I think it's always good to just have a look at the difference between employees and contractors and what's happening in that space. We'll also talk about sexual harassment. Obviously, that's been a topic of conversation for a few years now, but what we will see at the end of this month, the government is saying, is some changes to the legislation around sexual harassment coming out of what's called the Respect at Work report that was done by the Sex Discrimination Commissioner. I'll also touch on changes to modern awards, particularly in relation to casual employees. I'll look at workplace flexibility because I think that's going to be a very big topic as we kind of come out of COVID and everyone working from home, and then what that looks like and kind of the common questions I'm being asked, and then some other things to look out for on the radar. So coming first to minimum wages. So at the end of last week, the Commission handed down its decision in relation to the national minimum wage, and it determined an increase of 2.5%. And so that increase will take effect from the 1st of July this year, so the first full pay period after 1 July, and the national minimum wage will now be $772.60 per week, or $20.33 per hour. Now, in terms of who this is applicable to, so this is applicable to all your employees who are not award or agreement covered. So anyone that is not award or agreement covered, because that'll obviously have specific rates applicable, this is your national minimum wage. And this is the $772.60 is for your full-time employee. So obviously if you've got part-time employees, then that will be a pro rata amount. And also if you've got casuals, there'll be a casual loading. So in terms of what this means for organisations, it means that if you do have employees that you're paying the minimum wage to, then you need to look at increasing that to be reflective of this increase. In terms of the decision, so compared to last year, so last year the Commission increased the minimum wage by 1.8%. This year it's 2.5%. So there was a lot of speculation about what the increase would be, if it would be under 2%, given what we've all experienced over the last 12 months. Obviously, a lot of employer organisations were advocating for a lower increase, and your employee organisations, as you can appreciate, would have been saying, well, the increase should be higher. So the panel looked at a range of things. The kind of three things that I think were important was they said that the economic recovery has been better than what they expected or what was expected. And so they thought that that justified a bit of a bigger increase than what we saw last year. They also talked about the vaccine rollout. And that with that vaccine rollout, they thought that the likelihood of border restrictions and things like that would be limited or concentrated to certain areas. So again, they thought that that will all impact the recovery, and we will get back to normal sooner than what we expected. And the final thing that they took into account, well, there was a number of other things, but the third thing that I think that was important is that they took into account the superannuation increase that will come into effect from 1 July. So they took all of those factors into account and determined that the 2.5% increase was appropriate. They also talked about this concept of exceptional circumstances. So whether the national minimum wage increase from the 1st of July or whether it should be delayed. And they considered, again, that economic recovery and said, no, we can't really see any reason why it shouldn't take effect from the 1st of July. So that's what we have from the 1st of July. In addition to the national minimum wage, it also increased modern award wages, but it did so in a staggered approach. Basically what it did is broke the awards down into specific industries like it did last year. So for those of you who recall how they did the national minimum wage last year, they did it in 3 stages based on how they thought industries were affected by COVID. In this decision, they tweaked it a little bit because industries that they thought would be affected by COVID didn't see as much impact. For example, the retail industry. So there was a lot of talk last year about the impact on retailers. But what we saw sometimes was, for example, supermarkets, and they said homeware shops did really, really well because everyone was at home wanting to add nice things to their house because that was their new workplace. And also, obviously, supermarkets, everyone was out there buying toilet paper and whatever else they thought they needed to survive. So there were some aspects of the retail industry that did really well. So again, in terms of that modern award wage increase, they said unless there's exceptional circumstances that exist, then the increase should take place from the 1st of July. And so I've got on the screen there some of the awards that I think will be relevant to the people that are here today in terms of those awards that will have that increase from the 1st of July. Now, there is a whole list, and if you want that whole list, there's an article on our website that goes through all of the awards and has the decision, so you can go and have a look at that. But really, it's all of the awards other than these exceptional ones that we'll talk about. So I touched on the General Retail Award. So that will not increase until the 1st of September 2021. And again, as I said, they looked at that in some areas there has been a considerable uptick in terms of turnover, profit, all of those things. But for other industries, so other people in that industry, so for example, cafes and things like that, that might be covered by that award, there wasn't as much of an increase. And so what they said was, we don't think it was so significant that it needs to be delayed until November. We think September is appropriate. They also talked about the fact that this would mean that I think within the period of 6 months, they've had 2 increases. So you'll remember, as I mentioned, last decision, it was a staggered approach to a wage increase. So they did take that into account and say, well, those employers covered by the Retail Industry Award will have had to do 2 increases in a shorter period of time. But they said you need to weigh that up against, they had the benefit of not having a wage increase for longer than they usually would. So for about 18 months. So in all of those circumstances, they indicated that 1st of September, the wage would increase for the General Retail Industry Award. For those of you who don't know, the Ombudsman releases pay guides for all of the awards. So if you ever wanted to know what the rate is for a particular award and a particular classification, and also overtime rates and those types of things, I really encourage you to have a look at the pay guides because they're a really useful tool which gives you a breakdown of all of those minimum rates. And in terms of these recent increases, they're currently working on those, so they'll be out before that first full pay period. But you can go back, they have all the different years as well. So if you're doing a kind of reconciliation, if you're looking at potential underpayments, those types of things, those pay guides are really good. And then we have this last kind of assortment of awards. And really, these are the industries that they said were most affected by COVID. So your tourism, your hospitality industries, those types of things. And like sporting, events, those types of things. Gyms as well was one that they focused on. So these awards the minimum wage in these awards will increase from 1 November 2021. And so this is the comprehensive list, this is all of them. So basically what I'm saying is, unless you're covered by an award that falls into this category or the general retail, then all of your wages will increase from 1 July 2021. So you can see on the screen there, hair and beauty. So these are the ones that when we have shutdowns and even localized shutdowns, they said that they will be impacted more. So your hair and beauty, also your hospitality, other than those that can do fast food or click and collect, those types of things. Amusement parks, nurseries, as I said, traveling, so the airport employees award, those types of things. So it kind of makes sense in terms of how they broke them down. And the important thing to remember is that these don't come into play until the 1st of November 2021. I'm not sure if anyone here will be covered by those awards, but yeah, it's just something to remember. So overall, key takeaways, 2.5% increase. If you do have employees, again, that you pay annualised salaries to, you need to make sure that these award wages, they're being compensated adequately with that annualised salary, so that there's no underpayment or anything like that. If you have adopted the annualised salary provisions of awards, again, you'll just need to make sure that you've got the appropriate rates in there and that the annualised salary that you're paying these employees is covered by these increases. Because in addition to obviously that flat minimum rate increasing, it will obviously mean a subsequent increase to overtime rates and those types of things. The next thing that I wanted to talk about, oh, sorry, I just have a question here. Does it apply to apprentices? It will depend on the award, Belinda. So some awards will have rates in there for apprentices. So you just need to check that. So for example, the building and construction will have a rate for apprentices, things like that. Unless there's also obviously the Apprenticeships Act, which applies. Yeah. The next thing that I wanted to talk about is employees and contractors, which is always an issue, particularly for some industries. So some industries have a lot more contractors than others, but it does become a topic of conversation a lot of the time in certain industries. And again, when certain workers want to be contractors, when really the kind of the arrangement is one of employment. And when you're looking at whether an individual is an employee or a contractor, what the court or the commission will do is adopt what's called the multi-factor test. So it's an historic test which came from a case called Hollis and Vabu, which was about a bicycle rider that was injured. So he injured a person, and that the individual was bringing a claim, and they wanted to bring a claim against the organisation that the bicycle courier was engaged by, and that organisation was saying, well, no, this person is an independent contractor and therefore we have no liability. Whereas if they were an employee, then the employer would have been liable. So from that case, we got this multi-factor approach, and basically it's a list of things that the court or commission will look at and determine whether the individual is an employee or a contractor. And there's no kind of one factor that weighs above all others. It's really the court or the commission looking at the totality of the relationship. So they'll look at all of the relationship and say, okay, when we look at the factors in the multi-factor test and we look at the relationship, where do we lie? The important thing is just because you have a document or a contract that says the individual is a contractor does not get you out of a finding that the individual is actually an employee. Because again, what the court will look at is the relationship. It will go beyond the document that you have and look at the actual relationship. And we're going to have a look at a case involving Deliveroo. So on the screen there, I've got a couple of the factors that the court or the commission will consider. That's not the whole list. It's just kind of things that come up. Control is very important. So the ability to control the individual or how the work is performed is very important. The provision of tools and equipment. So generally a contractor would be providing their own tools and equipment rather than the organisation providing it to the individual. How they're paid. So generally a contractor would be producing an invoice and then paid subsequent to that invoice, whereas your general employee would be receiving a wage based on hours work. And exclusivity of service, which is an interesting one that we'll talk about. So what that's meaning is basically, can they only work for the one company? So is the worker only allowed to work for you, or can they work for other companies as well? An independent contractor sometimes will have multiple clients, and generally that's what happens. So for example, IT is contracted a lot. So if you have an IT person that comes in, they will generally have more clients than just yourselves. So they will be a contractor. So the case that I wanted to look at involved Deliveroo. So it was only last month that this decision was handed down. And in this case, the Deliveroo rider was found to be an employee. And the reason I wanted to talk about it is because it's different from decisions we've seen around Uber. So the Uber decisions to date in Australia have said that those Uber drivers or riders are contractors. And you would think Uber and Deliveroo are basically the same thing. So why did they find in this case that the rider was an employee? So they looked at a number of things in terms of the arrangement that was in place. The first thing I'll say is that there was a contract document in place that said this Deliveroo rider was a contractor. So it was basically called like a supply agreement. But basically what the commission said in relation to this was that this rider had no ability to kind of negotiate what that would look like. Basically, it was like a take it or leave it document. Whereas in a true contractor relationship, there should be some form of ability for the contractor to negotiate the rate. Because again, if you think of like a plumber coming in to fix your leaking tap at home, they tell you what the rate is and you say, okay, I need my tap fixed, so I'll pay that rate. So that's a contractor relationship. So again, there usually is, true contractor relationship, the ability for the contractor to negotiate the terms and conditions of that document. In this case, the rider wasn't able to do that. He was basically issued with the document, and then there were subsequent changes to that document over time. In terms of what's on the screen there in terms of the financial constraints, so again, he had no ability to negotiate what the rate was. So they just have a flat rate that you get paid a percentage of what the Deliveroo company is earning. The biggest thing, I think, was this concept of control, because the commission basically said, and this was decided in unfair dismissal claims. So the individual said he was unfairly dismissed, and the first threshold issue was whether they were actually an employee, because if you're not an employee, you can't bring an unfair dismissal. So what the commission said in relation to control was, if you just looked at it kind of on the surface, you would think that Deliveroo didn't have much control. And Deliveroo was saying, well, we don't determine when this person works, they set when they work. We don't determine the location that they work at, so they pick whatever location they're working at. And we don't have any minimum hours that they have to work. So we have no control over what they're doing. They just log into the app and say, I want to work in this location at this time, and then they'll get assigned jobs. And they also said that even if they select a job, once they get to the restaurant to pick up the food, and this was interesting because I didn't realise this when I was, before I read the case, that what happens, they don't know the location of where the food has to be taken until they pick up the order So when they get to the restaurant, that's when they're told you've got to go to wherever. And at that point, they still have the ability to say, no, I don't want to do that job anymore, which is sometimes why you get cold food, I think, because obviously someone said, no, I don't want to take that order. So they were saying, and they can even reject the order once they get there. So there's limited control over what this driver is doing. And the Commission said, yep, okay, on its surface, it looks like you don't have much control. But when you look behind it, you actually do have a lot of control over the rider, because what they had was a system where you basically logged in and you selected which shifts you wanted to do or what hours you wanted to do. And then the system assigned you whether you could do those hours based on a ranking system in terms of your performance. So how many of those orders that I said, where you can say, no, I don't want to do that order anymore, how many of those you had rejected and things like that. So they were given preferential treatment in terms of the kind of times they'd selected based on this performance data. So the Commission said, actually, you are controlling when they work, the hours they work, because you're using this system to assign the hours and preferential treatment to certain riders who are performing well and who have good delivery times and those types of things. And so this employee was terminated in 2020. So at the beginning of 2020, they did away with this system. But again, what the Commission said is there's nothing to stop Deliveroo bringing this system back in. So again, that creates another level of control. They can chop and change this system as much as they want. So they said in relation to that, there was a significant degree of control when you actually looked behind the arrangements. Another point was that they were given the option of having Deliveroo uniforms to wear. And obviously, again, the Commission said, whilst it wasn't obligatory, they didn't have to, the ability for them to do that, and it was obviously encouraged that they do that. So they were seen as kind of part and parcel of Deliveroo. Another important point that I thought that came up, which again is kind of tied to something we'll talk about a bit later on, is they talked about this concept of exclusivity of service. So whether he was just working for Deliveroo or he was able to work for other organisations. And this guy was actually working for other, so he was working for Uber and I think DoorDash or something like that. And so again, Deliveroo was saying, well, it's clearly not an employment relationship because he's doing work for other people and we allow that. And apparently this is called multi-apping, which is a new term I learnt. So basically you're logged on to multiple apps at the same time. And obviously if you're doing deliveries, you can do Uber or Deliveroo, whatever it is. And again, the Commission, and I thought this was an interesting point, said that with COVID, it's probably going to increase that workers are doing work for more than one organisation, and that in and of itself will not mean that there's not an employment relationship. So they gave the example of historically, if someone was working for McDonald's and Hungry Jack's, for example, competitors, because obviously Deliveroo and Uber are competitors as well. So if someone was working for McDonald's and Hungry Jack's, you had to obviously be physically present to do the work for both of those organisations. So you couldn't be doing work for the two of them at the same time. But what the Commission was saying was with COVID, we've seen a lot of technological advancements and people being able to perform the roles from home. Obviously, it's not going to be in the restaurant at McDonald's that you're going to be able to do, but they were talking more like call centres and things like that. So you could be working for two organisations, and they said this depended on how many internet points you had in your house. But you could be working for multiple organisations, but still be employees of each of those organisations. So just because you're working for competitors or able to have secondary employment does not necessarily mean that you're a contractor and not an employee. So I thought that was interesting because I think that probably will change and we'll see more and more people working for different organisations. Again, it will be limited because some organisations will have a restriction on working for competitors. So that will be relevant. But it was interesting because they were basically saying that the fact that he was doing work for Uber or DoorDash didn't prevent it from being an employment relationship. He was paid by invoice, but was using a template that Deliveroo provided as well. So the end result was that this individual was found to be an employee of Deliveroo. And for those of you who aren't aware, in an unfair dismissal case, if it was found to be unfair, the primary remedy is reinstatement. And obviously, because Deliveroo didn't treat this individual as an employee, they didn't go through really a very good process in terms of the termination. So the decision found that the termination was unfair. And then the decision reinstated this rider to Deliveroo and said you need to pay him for the time he's been out of work. So it's really important that you get your classifications right, because when you think about it, if you're dealing with an independent contractor or someone who you think is an independent contractor and you terminate their engagement, you really just issue a termination and say, we don't need you anymore. But if that individual is subsequently found to be an employee, you'll probably fall down on an unfair dismissal, and then obviously there'll be a decision, either reinstatement or compensation. So it kind of has a flow-on effect. So this individual, the decision was reinstatement. Now, what's happened since this decision? So I think this decision was like the 18th of May or something like that. Deliveroo has appealed the decision. So they have appealed and they've said, we don't agree with the commission. We think they focused unnecessarily on some significant aspects, and we think Commissioner Cambridge, I think it was, is wrong. And so they're appealing the decision. And so while that appeal is on, the order about reinstatement is stayed, but Deliveroo has to pay him a amount whilst this order, whilst the appeal goes on. So I think it's just important to remember that distinction. And this is a good example because we've seen a lot of Uber cases where they say they're contractors. And there's some distinctions between this arrangement and the Uber arrangement. And so in this case, they found that they are an employee. In terms of what those risks are, as I said, a determination that they are in fact an employee rather than a contractor gives rise to access to, for example, unfair dismissal claims, but also those minimum entitlements. So your national minimum wage, for example, or the minimum wage under a relevant award, those types of things. You'll obviously have liabilities for not withholding tax, leave accruals, all of those types of things. So it's not just, oh, they were an employee, we got it wrong. It's these risks. And also, obviously, if you've engaged in what's called sham contracting, so if you've misrepresented the relationship and you've done so knowingly or intentionally, then you'll also be in breach of the sham contracting provisions of the Fair Work Act. So that's why it's really important to get these classifications right. And I can appreciate as HR managers, which most of you are, sometimes managers will come to you and say, I want to engage this person as a contractor, when really you look at the relationship and it's an employment relationship. It's really important that you have those discussions about what the consequences of incorrectly classifying someone is, because it's going to have all of these impacts. Another interesting point is, so since that Deliveroo case, there was another Deliveroo rider who got terminated in the same way, and they commenced an unfair dismissal claim as well once this decision had come out saying, well, I'm obviously an employee and therefore I want to bring an unfair dismissal, but they were out of time. So you usually only have 21 days to bring a claim. So the commission said, no, you don't have significant enough grounds for us to extend your time to bring a claim. But it's just another point to remember that if there's a finding that someone is in fact an employee, you could have other individuals who you might have terminated within that period that would then have access to unfair dismissal claims. So it has a kind of domino effect. And what we've seen as well, so there's been an inquiry into this type of gig working relationships, and what Menulog have said they're going to do is trial an employment model, but they're also pushing for an award that will cover what's called the on-demand industry, which will provide minimum wages. And you can appreciate, for those of you who have awards that already apply to your organisations, there's usually like minimum engagement. So it says a casual has to be employed for at least a 3-hour shift or something like that. They're saying we want an award specific to this on-demand industry because we need greater flexibility than that. We want to be able to have people for 30 minutes or 1 hour or whatever it is. So I think we will see this growing prevalence for more of this on-demand work, and you'll probably see a new award come in. And you might also see changes to current awards that provide for these on-demand workers. But really my key takeaway is employers and contractors still on the radar. It is a priority for the Ombudsman as well. So they're out there doing audits on your engagements, and they are prosecuting for those sham contracting breaches. And so it is on their radar very much so. And obviously the Commission. And so what happens, so in this Commission situation, what the Commission, Fair Work Commission can do is refer organisations to the Ombudsman. So they'll say, we think this is more systemic than just this individual and you should have a look at this organisation. And that's happened in the past as well. The next thing I wanted to talk about is sexual harassment. So as I said, it's obviously been a hot topic for a number of years now. And we had the Respect at Work report come out last year, which made recommendations around changes that we need to see so that sexual harassment doesn't happen, and particularly focusing on the workplace. And so what the federal government has said is that, yes, we're going to make or adopt some of those recommendations from the report. And those proposed changes are due to come out at the end of this month. So we'll send out a update around what those actual changes will look like. But basically, they've told us what we're going to see. And that is sexual harassment will specifically be included in the definition of serious misconduct in the regulations. So in the Fair Work regulations, there's a definition of serious misconduct. It doesn't specifically at the moment say sexual harassment. That's not to say that it is not a ground of serious misconduct. I think it is, but it's just giving employers kind of that reference point when they're terminating employment on that basis to say, yes, it falls within the definition of serious misconduct. So it will be specifically referenced. It will also be specifically set out that it's a valid ground of dismissal. So if someone is found to have sexually harassed another employee or client or whatever it is, it will be a valid reason for dismissal. What we will also see, so at federally to bring a complaint, at the moment you have to bring a complaint within 6 months. And what is currently proposed is extending that to 24 months because the report basically found that 6 months is not long enough. It takes some people quite a while to be comfortable enough to raise these things. So what they're saying is we want to extend that period to 24 months, which for organisations means that you could have an employee that left 2 years ago that brings a complaint of sexual harassment. And the other important thing I think for organisations is there's probably going to be a provision for what we call a stop sexual harassment order. So it'll be very similar to the stop bullying order. So at the moment, if you bring a bullying claim, the Commission, if it goes all the way to hearing, can make a stop bullying order. So it can order certain things to happen in relation to the bullying, i.e. the manager and subordinate not to have contact or things like that. So there'll be something similar in respect of sexual harassment. So employee X and employee Y not to have contact. And if there's no policies or procedures in place about sexual harassment or training hasn't been undertaken, the Commission or court will be able to generally order that the employer undertake training or update their policies, those types of things. So those are the kinds of changes that you will see. I think there'll be more than this, but this is what has been alluded to so far. And again, so from a in practice perspective, again, your contracts and things might already say that sexual harassment is a valid ground for termination, or your policies might say that, but you can then look to insert that specifically into your policies and procedures and contracts in relation to termination of employment. And then obviously, if you're dealing with complaints of sexual harassment, just be mindful that that they could potentially be now able to make a claim for this stop harassment order. We'll have to see what that looks like in practice, and also that there's this probably going to be a period of 24 months rather than 6 months to bring a claim federally. I did a webinar a while ago around the casual changes in terms of to the Fair Work Act, and now we have a definition of a casual employee in the Fair Work Act, and we have obligations around casual conversion and looking at that. So I'm sure most of you have probably started to work through that process. Along with that, what the changes required is the Commission to look at the casual terms in modern awards to see if they are consistent with the definition in the Fair Work Act. And for those of you who didn't attend the webinar on casuals, if you send me an email, I can send you the recording and the slides if you like. So basically what the Commission has to do is by the 27th of September have looked at all the awards and checked that it's consistent, or the concepts of casual are consistent with the Act or don't create uncertainty. And so what they've done is chosen 6 awards, which they're looking at initially, which basically all the other awards are similar to. And there's going to be a hearing, I think, at the end of this week, where there'll be some decisions around the awards. But what the Fair Work Commission has done is expressed its provisional views around these changes. So these are the 6 awards that they've looked at. And then in terms of their provisional views, the first question was, so there's some awards that don't allow you to employ casuals at all. So it says casual employment is excluded. And in relation to whether that is inconsistent with the Act in terms of the definition of casuals, they said no, because there's no definition of casual employment. You can't employ a casual, so it's not inconsistent with the Act definition. In terms of a definition that says engaged as a casual, so sometimes in an award, and there's some examples on the screen there, you'll see the award says a casual employee is one engaged as such, which is very helpful, not. In terms of that definition, they've said that that is inconsistent with the definition we now see in the Fair Work Act. So we have to change that basically. And so we'll see some changes to those awards that have that as a definition, and I think it will most likely reflect the definition you see in the Act. In the pastoral award, again, you'll see changes to reflect the Act because it's saying it's inconsistent and creates uncertainty in relation to the definition. In terms of the casual definitions in some awards, they're saying, the question was, well, should we just replace it with the definition in the Act? And then that will operate and not be inconsistent, because what we can't have is awards that are inconsistent with the Act. So they're saying, yes, if we replace the definition of casual in the award with what we now see in the Act, then they'll basically be consistent and operate effectively. So I think that is likely what you will see, and that's what the Commission has expressed its provisional view that it will do. The other point, so some awards say that you need to inform employees that they'll be engaged as casuals. And again, the Commission has expressed a provisional view that yes, that is consistent with the Act. But there are some awards that say you also need to tell them like kind of what the hours are or things like that. And again, the Commission is saying we'll probably vary those awards to say you'll need to give kind of a non-binding view about what kinds of hours you might have as a casual. Because we need that no regular firm advance commitment to an agreed pattern of work to be a casual. So you'll see some changes around minimum engagements, I think, and things like that in respect to casual employees. There was also a question around fixed term or maximum term employment and casual employees, and basically the Commission has said no, they're not consistent, because again, to be a casual you need to have that no firm advance commitment, and a maximum term or fixed term employment generally would say that there's a commitment to some ongoing work for a period of time. So I would generally say that as a casual, you wouldn't be engaging them on a maximum term or a fixed term contract. There are clauses in many awards which talk about loadings applicable for casuals, minimum engagement periods, those types of things. The Commission's provisional view is that those aren't inconsistent with the definition in the Act, so they work with the Act. But what you'll probably see is them become separate terms. So you'll have a definition of casual, and then you'll have information about minimum engagements and a casual loading and how often you have to pay them, those types of things. So we'll probably see them a bit more split out than what we normally do currently in the award. And the other one was the casual conversion clauses. So we did see some changes to awards which now include casual conversion clauses. And the question was, are those casual conversion clauses in the awards consistent with the casual conversion obligations we now see in the Act? And the answer is no, they're not consistent, and they create uncertainty. And again, I think what you will generally see for the most part is the casual conversion obligations in the Act will be now in the modern awards. So whatever the modern award now says will be replaced with the Act, again, to make them consistent. So all in all, I think what you need to take away from this point is that the definition of casual employee in the Act and the casual conversion obligations and the residual right to request conversion in the Act will basically now also be reflected in awards. So they'll be consistent. So you'll see some tweaking of awards to make them consistent with the Act obligations. And again, once that comes into play, we'll issue a reminder and a little update about what that looks like in practice. But that's just something to keep on top of to make sure that we're consistent with the award obligations. The next thing I wanted to talk about is workplace flexibility. So we are seeing employees come back to the workplace. And I've had a lot of questions from clients and HR managers around employees that are resistant to returning to work and what we do about that. Because everyone likes working from home, you know, and the couple of extra hours you get. So in terms of that, I think what we'll see going forward is a hybrid arrangement where people will work from home probably more often than what we saw pre-COVID. But there will be an expectation that they come into the office sometimes, particularly for meetings and things like that. I think the main thing to remember is that as an employer, obviously you can require your employees to be in the office, but there are those flexibility obligations or the ability to request flexible working arrangements under the Act. So if an employee, for example, has care of school-age children or something like that, or falls within one of those sections of the Act in terms of carers' responsibilities, things like that, and they're requesting flexible working arrangements on that basis, you still have to assess that request in accordance with the Act. So can it be accommodated? Are there reasonable business grounds to refuse that request? But if it's just an employee saying, I don't really want to come back into the office, and they're not relying on any of those protected grounds under the Act, then there is no requirement for them to stay at home. You can direct them to come back into the office. Again, as I said, I think you'll probably see a mixture because most employees have been able to show that they can do their jobs from home. There also will be roles that are required to be performed in the office or in a factory or whatever, and there's no option for them to work from home. But I'm more talking about those roles where people have been working from home for the last, for example, 18 months, and then you say, okay, we slowly want to bring people back to work, and they're saying, actually, no, I don't want to do that. So in that situation, like I said, you need to consider any discrimination grounds, for example, flexible working requests for parents, children, or if you're caring for your elderly parents or those types of things, you still need to consider those requests. But other than that, again, and you would need to look at your contract and things like that, but I would presume that, again, you can give a direction for them to be in the workplace. If there's medical grounds, so some employees are prone to getting, for example, COVID because they have medical contraindicators or things like that, then that might be a reason why they stay home, things like that. So it's just, you need to assess each case as it comes. In terms of what I'm talking about, flex roles, so I wanted to raise here something that I saw that Telstra is going to do, which they call location agnostic roles. A lot of new terms coming about as a result of COVID. So basically what Telstra is saying is we will have roles where we don't care where you're performing the role. So there's no specific location, it's location agnostic. So you can be doing it at a cafe, you can be doing it at your home, you can be doing it on a cruise ship, not right now, but maybe later. So they're saying we don't care at the location you're performing the role. And they're saying we think that'll increase our talent pool and the types of employees that we're getting, because we're not saying you have to be in the office. And I think that ties in very well to the point I was talking about when we were talking about the Deliveroo case, where the Commission was saying it's no longer the case where you can't work for more than one company at the same time. And I think this kind of plays into what the Commission was talking about, because Telstra, as you can imagine, and they're talking about bringing all their offshore call centre back to Australia. And so you could see call centre people working from the cafe or whatever, and they might be working for more than one call centre at a time. So I think that plays into what the Commission was talking about, and saying that just because you're doing work for more than one organisation and might be doing that at the same time, that doesn't mean you're not an employee. So again, it's just something that I think you might see more and more of in terms of organisations moving to, and I would say probably on the larger scale organisations, moving to those types of location agnostic roles, and they think that'll bring more talent and get them better candidates, again, because there's no prescription on where people are performing the work. Obviously, vaccinations is a hot topic. I think in terms of vaccinations, we've seen some cases, which we talked about last webinar, around the refusing to get vaccinated in certain circumstances. I think that will be very industry specific and very dependent on the circumstances. But what we have seen, particularly some banks do to encourage people to get vaccinated, is give them vaccination leave. And most of the people that I know that have had a COVID shot have said that they felt pretty bad the day after. And so what we've seen some banks do is, I think it's CBA and maybe NAB, is give 2 days leave if they have the shot. So you get the day off, the day you have it, and then the day after. And again, they're saying we're not directing employees to take the leave, but we are providing every opportunity for them to do it and not be at a detriment, like, for example, to have to dig into their sick leave or personal leave to have to go and get the vaccine shot. So again, I think you might see more and more of that happen in the workplace as a way of encouraging employees to go and get vaccinated, particularly in industries where you're very client facing. I think that you might see that. And then the last thing that I wanted to touch on in terms of flexibility is mental health. So again, with people coming back to work in the workplace, I think and mental health's obviously been a topic on the radar for a while now, but I think, again, you might see that being raised as maybe a reason they want to come back into the office, or maybe they don't want to come back into the office. So again, you will just need to assess that on a case-by-case basis. And I also think you will have seen recently in the media, obviously Naomi Osaka citing mental health reasons for not participating in media interviews. And then for those of you who watch MasterChef, there was a contestant on there that said he was no longer continuing because of mental health. So it is something, and I think it's very relevant because both of those situations are probably workplace relevant. And again, we need to be mindful that mental health is something that's going to be very prominent, and you will see, I think, employees probably hopefully feel more comfortable to raise it with their employers. And then it's about how you work with those employees to assist them in that mental health and hopefully get them back to the workplace. But I think it's something that will be more and more on the radar, and I think talked about a lot more. And I think, as I said, when we see these kind of high profile people talk about these struggles, it makes people more comfortable to talk about it. So I think also you need to make sure that your managers are trained in how to have these conversations with employees that do disclose these kind of struggles that they're having or whatever's going on for them. Because again, in practice, what I find is sometimes as soon as a manager hears the word mental health or I'm having issues, they kind of think, oh, I don't want to say anything wrong, and then kind of don't say anything at all. Whereas we need to be training our managers on how to have those conversations so that we can manage it. And we are working with employees to obviously manage their health and hopefully get them back to full capacity and working. And the last thing that I wanted to talk about was just some other things that I think will be on the radar. We've talked about underpayments. So again, as I said, that I think will still be a priority for the Ombudsman. And employees are very well educated these days. So if they think they're getting underpaid, they'll go to a lawyer or a HR person and you'll get a letter saying this is the underpayment. And it generally comes about, so for those of you who've been watching the media or watch the Fair Work Ombudsman media releases, Woolworths has recently, so they've started to prosecute Woolworths for underpaying their salaried managers. So those managers are covered by the General Retail Industry Award, but they were paying them an all-inclusive salary. And of, I think it was 70 managers that they looked at, though they were underpaid when you compared what they should have got under the award to what they were being paid in the annual salary. So if you are paying annual salaries, particularly with that increase to the minimum wages and the modern award wages, you need to be checking that there's no underpayments. For those Woolworths managers, most of those underpayments arose in respect of overtime. So they were doing hours in excess of 38, for example, or outside the kind of hours that the award says you can do your ordinary hours of work. So I think it's something that will continue to be on the radar and continue to be prosecuted by the Fair Work Ombudsman. And so you need to stay on top of it and make sure that you are paying correctly. And that's where those pay guides are really useful in terms of helping you make sure that you're paying those correct rates. And like I said, they break it all down for you, including Saturday and Sunday rates, all those types of things. Wage theft, which kind of ties into your underpayments as well. So we've seen some wage theft laws come into place in Victoria. And what that Victorian government has done is now appoint a former Fair Work Ombudsman executive to what's now called the Wage Inspectorate Victoria. So there's an act called the Wage Theft Act, and it's a crime for an employer in Victoria to deliberately underpay employees or dishonestly withhold employee entitlements. So they've appointed this Fair Work Ombudsman executive to undertake that key role, and obviously there'll be a whole inspectorate under him. And so again, that's why I think that your underpayments and making sure you're getting your entitlements correct is going to be very important for the next year, and I think for years ahead, because this concept of wage theft and underpaying employees is very topical, very talked about, and you'll see, I think, more and more states adopt a similar approach to Victoria in terms of wage theft and making it a crime. And obviously it's deliberately underpaying employees or dishonestly withholding. So if you haven't done it knowingly, then you're probably not going to be in breach, but you still be responsible for the entitlements, and you'll still have penalties imposed if you are prosecuted by the Ombudsman or someone brings a claim. So that's, I think, something to remember, and I think it ties in nicely with those annual minimum wage that we talked about right at the beginning. That's, I think, it in terms of what I wanted to talk